My Lord, my former friend resumes. I'll just confirm that the schedule has been agreed and has been sent to your Lordship's clerk.
Right. I don't think, because we've been on the move, that this has reached us yet. And remind me, this is the schedule of...
With the whereabouts of the children and the safety.
Yes, that's very helpful, and no doubt it'll come in during the course of the hearing, or we'll get it later. Thank you for doing that. Yes,
Lord, and I should say that Miss Griffiths, who attended me today, has been the instructing lawyer for some time, and she was able to, she was aware of the details, so has discussed it with
That's very helpful. Thank you to her as well.
Yes. My Lord, I wasn't clear from my Lord's comments before the lunch adjournment whether you would wish me to address you any further on the issues of the factual errors made by the judge.
Well, I think the last thing we want to encourage is you, as it were, to retread the entire road. But I mean, on the face of it, speaking myself,
yes,
it seems to me that Miss Newton has identified certain issues of fact which the judge appears to use to cast some doubt on the credibility of the family members, individuals, which are either in a couple of cases, as it were, accepted by the judge but considered by him not to make any difference.
Yes.
In a couple of other cases, ones which may seem plausible but didn't get referred to below, and then a number which, again, speaking purely for myself, just seem to be matters of argument. So yes, I on the basis that there might be plums and duff in all of that, you're going to need to deal with such parts of that as might be said to show that the judge, it's not so much that he didn't have a grip of the situation. I'm not so, if I may say so, impressed by that, but more that he didn't carry out the exercise that he needed to, which was to actually assess what all that led to.
Yes, I suppose this is why I asked, because I think, as Maud said, that there were clearly some errors which he accepted. He said they didn't make any difference, and if one would just take the clapping and tapping point, I mean, I think one can see, and I've made the submission in my skeleton, that doesn't make any difference. As to whether or not the different accounts by various relatives in different places, I mean, I think factually most of those are probably correct. They have said different things at different times. Of course, Mr. Newton makes the point, well, that's to be expected, and I mean, I entirely understand that point. But Lord, I anticipate the real point is...
Although, in this court, you may say you understand the point, but it may not carry much weight, because, I mean, simply an assessment of the credibility or otherwise of witnesses, or the balance of weighing the balance of factors, is not normally something that's retrod in this court, is it? Unless the judge approached it wrongly in principle.
Yeah, no, I think, well, right. I mean, I suppose what I'm trying to say is that the learned judge ultimately dealt with those issues correctly, because the issues that were raised on credibility, first of all, some of them he raised himself in terms of different accounts.
Yes, that's
and
right.
He put to various of the witnesses that they had said various different things. So my submission broadly would be that he was entitled to point out that there were differences. If I've understood the law correctly, then it's the next point, really, which is the key point, which is where did that lead him? Did he deal with it correctly? And did that, for example, mean that he should have made individual findings on credibility, on the issue of the fall, on the issue of...
well, that's certainly we're going to need to hear you on, as you say. But I think the point that I'd just like your position on, don't have to do it at any great length, is this, that at paragraph 203, the judge starts by accepting that people don't necessarily see and record things in the same way as others. But he says, in this case, there are widely differing accounts. And he singles out the older daughter and the grandmother.
Yes.
Whereas in the permission to appeal judgment, he describes them as being relatively consistent accounts. Now, people speak in certain ways, but he seems to be using differences or inconsistencies, however one describes it, inferentially to support a rejection of the family's case in the judgment. But when he comes to deal with permission to appeal, he considers, as one might consider objectively, that the accounts that were being given were broadly consistent. I mean, that's something that we're going to have to grapple with whether the judge is on a page that he was entitled to be with one statement or with the other.
Well, I think my submission would be that there was a core consistency. Each of the family members, in their different way, described this child falling. Although there are differences insofar as there's a record of the grandmother having said she fell from the sofa as opposed to, and of course there was a report to the ambulance to that effect. My understanding of
speaking of myself, I tend to agree with that submission. But in that case, how are we to deal with what the judge says? His assessment is that they're widely differing accounts.
Well, because when one comes to look at the way that the child fell, the way she landed, whether some did or didn't, I think some of the relatives clearly say they didn't really see it, as you were just taking some before the lunchtime. So coming to one of the points made later, which is whether or not he should have referred to the evidence of SH, was that effectively she was saying she didn't really know what had happened and hadn't clearly seen. So my response to that would be that really can't be a fundamental error when put together with the point that my Lord made, which is that the judge doesn't have to recite every single piece of evidence they had made reference to.
You'll have to deal with that, however, when it comes to the question of how he put it all together, because you can't ignore somebody and then make a finding in inverted commas finding, because it's a pool finding. It's not a legal finding. In respect of that.
Yes, I mean, there were clearly differences in accounts given previously and before, as I've said, and there were differences in the way that she was, arguably the way she was said to have fallen. There is the business of whether she wasn't or wasn't jumping up and down, although it's only the father that he was told that. SA, for example, at page 230 of the bundle, is recorded as having said that her sister was holding the child. She then just fell back onto the rag doll and the head hit the carpet. So there were those sort of details. My understanding of what the judge and what I would submit is that the judge was really drawing more detailed differences between the relatives and their previous accounts. And it were those concerns that led him to be, what were the words he used, I think, to have concerns about the veracity of what had happened. Or,
sorry, I think if we're talking about SH for a second, I mean, the issue which you need to get on, either you are going to deal with, or in which case tell me to shut up and I'll wait until you do, or you do need to deal with, is that, as was said earlier, the judge, in effect, although not expressly at all, put her into a list of potential perpetrators without having dealt with her evidence, critically or otherwise, at all. And that's the problem, isn't it, at least as far as she is concerned. But that is an illustration of a wider problem with the judgment, which is that the judge never actually squares up to the question that if, as he has found, the baby was shaken, or the child was shaken, then a lot of the people he heard evidence from, all of them, are lying to cover it up. And he never actually grapples with that head on. I mean, that's the problem that exists, isn't it?
Yes,
that's the core. I mean, it was introduced, I think, by Mr. Newton as if the judge had made those findings. I mean, the real problem is he never actually grapples with that.
No, I mean, he rejected the count. My submission, as I've put in the skeleton, would be that he didn't do so because it became increasingly clear on the basis of the medical evidence that fall could never have accounted for the injuries. And so he...
well, in that case, he could have stopped after day 8.
Well, no, my lord, he was entitled to look to the lay evidence to hear what they had to say.
Sorry, but that isn't... Sorry, but that's the very problem. That isn't the finding he made in relation to the medical evidence. If you look at the medical evidence, his finding is summary of the medical evidence. I mean, you're putting that into the sort of re-B type case. His finding at 178 in relation to the medical evidence, when he runs through the list, first of all, he accepts that the injuries could have, or one of the injuries could have resulted from the fall, but it's more probable, shaking event, and then uses the same expression, more probable, in sub 3, more probable in sub 5, unlikely in 6. I mean, that's nowhere near saying basically it's a slam dunk on the medical evidence. There's just the family's account has no relevance. If you've only got a more likely type finding of the medical evidence, you've got to then weigh it against the other family evidence, haven't you?
Well, I'm not saying that it's of no relevance, of course. He went on, he himself said he had to consider it, but he was entitled to look to the family for a possible explanation or some further evidence. And obviously they hadn't given it in writing, but it wouldn't be the first time that evidence emerges. And I suggested one possibility was that someone might say, well, she fell, so therefore the consistency of the fall, but she then appeared dazed and someone then shook her in a moment of panic. But no one did say that. But that's why he had to hear the evidence in case someone was going to say that.
Because nobody did say something like that, they all said, there was no shaking. It was just a inconsequential fall, I think, as you said at the start. That was the consistent evidence of the family, in effect, as between themselves. Yeah. Hasn't he got to square up to the fact, as he said in 201, I think, that it looks as if, these are family members keen to show a united front and giving the oral evidence. The simple explanation is they wish to protect the family member who was responsible for the injuries. I mean, he never actually squared up to the consequences of his own analysis in that respect. I mean, hasn't he got to come out and say, I reject the family's accounts and do so for the following reasons? Because in effect, he's putting one of them in the bracket of perpetrator and the rest in the bracket of cover-uppers.
Yes. Well, my lord, he did clearly reject
I'm sorry to interrupt, but he's putting them both in both brackets. They're putting them all in both brackets.
Well, potentially,
yes.
That's right, yes.
Yes, he is. Well, I mean, he clearly did reject and was entitled to reject the family's account. The reason, of course, he went on to say that he doesn't go further is because he said it would be speculation. And he pointed out the reasons why he said he wasn't convinced by their account. But as I say, the fundamental reason is that it didn't go towards explaining the what I would say was very clear medical evidence. So I agree it's not quite in the B category, but it goes, ironically, I would submit it goes further than the judge actually found. If one looks at the transcripts of the medical evidence, that the doctors are really very clear that this was not at all likely to have been caused by this low-level fall. Lord, really, that is the point I make. I say that he didn't have to go further than he did. He was entitled against that medical evidence to consider the family's evidence, which he did. He raised concerns about the veracity, and he said both in his main judgment and his clarification judgment that he did consider that it would have been improbable for it to have happened in front of everyone, but what he was essentially saying was that he didn't feel that he'd been given the full account or an account which would explain these serious medical injuries, and for those reasons he believed it was appropriate to make a finding on the local authorities' assertion that these were inflicted injuries. I think I said in my skeleton, I think it would have been perhaps more helpful if he had addressed the issue of the fall, because it was, after all, what the family were putting forward as an explanation. I'm well aware of the cases that make it clear that the family, in a sense, doesn't have to put forward an explanation, but of course in these cases there almost always is an explanation to be considered. But he was entitled to conclude that the evidence that he heard did not explain the preliminary conclusions on the medical evidence. He bore in mind the family's good character generally, including those of the interveners, and he therefore did consider the wider canvas, which he was obliged to do, and he, in my submission, can't be criticised for addressing the issues in that way. with the medical evidence in mind, he was approaching the situation, I submit, where the passage in Re B, Baroness Hale's passage, was apposite. I appreciate the Lord's earlier comments about that, but the judge, as I say, in my submission, sort of essentially underplayed the strength of the medical evidence in his conclusions there, and he was entitled to effectively conclude that...
but there's no cross appeal in relation to that. I mean, you may say that, but haven't we got to basically go by what the judge himself, the view he took of the medical evidence? I mean, irrespective of the question of what permission to appeal there is, I mean, that's what he says. He doesn't say, I can entirely eliminate, I'm entirely satisfied that there's no possibility that this was simply a fall. Therefore, I only have to decide who the perpetrators are, or if I can. I mean, he just says it's more probable than not, for various reasons, that this was shaking, not a fall. So hasn't he got to sort of then look at the other side of the coin and say, well, in assessing the probability it was just a fall, I need to deal with the family's evidence to that effect?
Yes, Lord, and he says himself that that's what he does, and my submission is that he does do that. He explains why he isn't effectively convinced by it, and why, as I say, he concludes ultimately in 203 that the differing accounts cast doubt on the veracity of some of the evidence I heard, placing weight on how she sustained her alleged fall.
I think it's a short point, and I don't want to belabour it, but I just have to say that I simply can't accept that it's in the same category as the case referred to as by Baroness Hale. But a number of us may have come across cases in which you have, for example, a very small child who, to take an instance, is in a home and has a skull fracture of a kind that has been caused by a heavy blow with an instrument, because the skull is so caved in that there is only one possible way that could have happened, and the child couldn't possibly have caused it themselves. Now, in that situation, you know that the child has been assaulted, and so the only question is who, and that's what we're talking about in the Re B example that is given, namely that, you know, to treat a baby like that is incredibly unusual, but unfortunately this is a baby who got treated in that way. But that's where any other explanation is impossible. It's not where it's improbable, and as soon as it's improbable, it's in agreement with my lord. At that point, you have to work out where the evidence takes you, having regard to the probabilities or improbabilities, don't you?
Well, my lord, yes, and I say that he did do that.
All right.
He as I say, he considered the accounts. He was sort of dissatisfied to some extent with each of them, although, as the Lord says, he mentioned there being a sort of type of core consistency. And also took into account in 207, for example, very conscious that two of the extended family members are carrying profession, etc. So he took into account the right factors in my submission.
That almost begs questions of its own, because when one looks at 207 and follows this up with 212 and 213, and particularly 214, I'm not understanding why the judge, if he's making findings against this group of such seriousness, in many people's minds, the cover-up would be more serious than the shake, because people can shake babies in a moment of lost self-control entirely out of character, whereas to lie to everybody for years and deprive the child of protection that it would otherwise receive might be described as being even more serious than what happened there. So I don't at the moment understand how the judge can be asking regulators and employers to look at this in a benign way. The two of these aunts are either involved in, one is involved in nursing, another is involved in running children's care homes. Extremely serious conclusion to have reached. But the punch seems to be being pulled here.
To put Lord's point, a follow-up, if you look at the beginning of 209, the judge says, having determined that the child's injuries were inflicted, I'm invited to conclude that the named individuals colluded. It seems to be an afterthought. I mean, surely the likelihood that they would in fact have colluded or not should actually have been relevant to his determination as to whether the injury was inflicted or not. He seems to reach his conclusion that the injury is inflicted without actually taking into account the inherent improbability, not only that people in this type of in the nursing profession or otherwise would have done it in the first place, but more particularly that they all would have covered it up. It's almost like an afterthought, whereas in fact surely that's the very exercise of assessing the relative probabilities he should have been doing, namely saying, on the one hand I've got medical evidence that says it's more likely, more probable, but it's not certain. There, on the other hand, I've got to take into account the fact that is it likely that people of good character in these type of professions would do it, or more particularly, that they'd all lie to cover it up. Surely those are the two elements of the weighing of the probability, whereas he seems to have done one and then just sort of declined to follow through, which seems to be
Yes, I think that was because
inverted,
there was a separate finding in the local authority's threshold that there had been collusion, as opposed to the infliction of the injuries. Which
yes, I know, but what he's not doing is putting into account, I think the way it's put is not taking into account the inherent improbabilities of both infliction by this group in these circumstances and the collusion when deciding whether he could in fact
conclude the
stick with the medical evidence.
I
mean, that's the problem, isn't it? I mean, those words, sort of picking up my Lord's point, sort of rather suggest he's actually done the exercise the wrong way around and then failed to follow through.
Lord, I'm not sure that there's anything further.
No, I mean, just while we're finishing on this passage, again, I wanted to ask you about 210, in which the judge draws the analogy halfway through that paragraph between a finding of collusion and a finding of failure to protect. And he says that in some ways that they're analogous and that a finding shouldn't be a bolt-on finding. I mean, I think the counter-argument, to give you an opportunity to deal with, is that far from being anything bolt-on about it, that your case that was put to the judge was completely coherent, and one followed from the other, or went with the other as night follows day, that if this was not a freak accident, then obviously the family had colluded, and the judge accepts that at the beginning of the paragraph as a starting point.
Yes.
But can you defend his departure from that starting point? There isn't a cross appeal, as my lord has said.
No.
But I mean, if you were right in relation to the first one, you were really entitled to the second finding, weren't you? Of course, the judge wasn't to know who said what to whom, although
No.
they would have had to say it quite quickly.
Yes, I have to say I've thought about this, as you will understand. I didn't know whether there was something in the word collusion that was almost putting it too highly, because of course there doesn't have to be active collusion. And he went on, didn't he, talk about telephone calls between people and things like that. There was no evidence of any of that.
No, but evidence can be, obviously, it can be, I've said this in various places, it can be in innumerable different forms. But I mean, one sort of type of evidence is circumstantial evidence and evidence that you infer from other evidence and so forth. So, I mean, clearly, nobody, if they were going to lie their way through the trial, was going to tell you how they decided how to lie.
No.
But the fact that there isn't actual evidence of it happening can't be a barrier to a finding. But the judge seems to have thought it was.
Yes, as I say, I'm speculating whether that was the word collusion, but in a sense, one uses different words. The family didn't tell the truth collectively, or they covered it up. That possibly implies less than collusion. I don't know whether I'm reading too much into it, but Lord may have the point. But that's the only, I think, distinction I can draw between what I respectfully agree is the finding that ought to follow, given the local authority's case, and the lack of collusion. Yeah. Sorry, lack of finding about it.
We know what the judge thought what was being meant. Because he says, paragraph 5, what your submission was that the injuries were inflicted. Finding really sought to the effect the list of perpetrators colluded to invent an explanation for the injuries and present this to the authority in an attempt to deceive them into believing that the injuries had been caused accidentally. So it's not very hard to know what collusion meant or what the judge understood. There we are.
Very well, Lord. Lord, I think that's probably all I can say, really. I have taken instructions on the important point as to where one might go.
Yep.
And obviously the local authority have given this careful consideration. They do not believe, were you minded to allow the appeal, that it would be proportionate or appropriate to order another fact-finding hearing. There are a lot of reasons behind that. This was a family, as you'll have picked up, that was not known. There were no injuries or any concerns apart from the concerns about the eldest child at the school, which really aren't and never were child protection issues. And then I'm afraid to say you will understand for a local authority that there are massive funding and cost
implications,
which, has been said in various other cases, such as the residential assessment cases, deprives other families of resources. And so all in all, we do not believe that would be appropriate.
I'm very anxious that, firstly, we understand that this discussion is taking place in a hypothetical context,
yes.
although you'll have gathered some of our thinking from our questions.
Yes.
I'm also concerned to recall that the children's guardian has not, as a result of my directions, formed part of today's hearing. But I think what I would like to do, once we've heard any reply from Mr. Newton, is for us to rise for a moment so that the court can just take stock of what you told us.
Yes.
But at all events, it is something that the family and the guardian ought to just have a point in time, by which I don't mean this afternoon necessarily, but in the immediate future, to reflect upon and to make any comment upon. I think the mechanism by which that would be achieved, if it was the right approach, would be by the proceedings being withdrawn by consent.
Yes.
Would it not? You would, on the basis that there would be some recital, probably, I think, that preserved what ought to be preserved from this in point of a record. There is a record in the judgment in relation to the medical evidence, in a sense, which has stood undisturbed. But the net effect would be that there would be no finding about how these injuries were caused, and that's how the record would stand for the future. There would be no compulsory intervention with the family, although the local authority's ongoing duties towards these children, as to any other children in its area.
Well, I was about to mention that, Lord, the supervision order would obviously have to be discharged because the judge made one.
Yes, well, absolutely.
That must follow because the
No, I agree.
Yes.
But instead of substituting an interim supervision order, which is what we would do if you wanted to retry it,
quite,
it would just simply be discharged,
yes.
And so there would be no court order in effect.
That's
but
right.
every child in your in your area is entitled to the protections that you're able to bring, and these children will be no different.
That's right. Well, Lord should understand as part of the discussions when, quite rightly, we were asked what our position was in answer to my Lord's question before the lunch adjournment on this issue. I indicated that the local authority would welcome to continue work with the family, as you say, on a voluntary basis, and probably under a child in need plan. And I don't think formal instructions have been taken, but certainly there was an impression that that would be very...
Well, this is the sort of thing that I think the family ought to have the opportunity to reflect upon. But speaking for myself, it would seem to me that that would be a very sensible approach for the family to take, because it doesn't just give confidence to the professionals that they are able to keep an eye on the situation. It also gives confidence to the family that there will be no misunderstandings, and that what has clearly, we've been given the chronology that you very kindly prepared. Thank you. I think to Miss Hunt and others. I mean, whatever happened, this has clearly been an absolute nightmare.
Yes.
For the family, and the availability of services and support, I would hope, would still, after all that has happened, be seen as being an asset or some form of reparation, rather than unhelpful or something of that sort. But my lords have not had an opportunity to contribute to this yet, and so after we've heard from Mr. Newton, I'd like them to be able to have some input into this before we leave and decide what should happen next.
And Lord will recall that one of the other important features that will need addressing is that the elder child remains out of the house.
Yes, it wasn't clear from the little I've seen, but it may be from attachments to the message. Is this an overcrowding issue?
No, it's, I think, was a... it was a, I think, if I understood, make sure the other children return first, and then, because she remains within the family, the other child.
So it was a phased return type
Effectively, yes.
approach?
Yes. Right. But it's just another example of an area where we would say ongoing support would be helpful.
Right, well, that's been an important contribution. Thank you. We'll reflect on that and come back to it.
Thank you.
Yes.
Yeah, can I just ask you this question? It's not a very important point, and it's certainly not one picked up on behalf of the appellants, but if you go to paragraph 25, I just wonder whether this is a usual sentence to have in family proceedings of this type, which is when the judge, before he's even started assessing the evidence, directs himself that it's common for witnesses in these cases to tell lies. Speaking for myself, where all you can hope, whatever you've done, is for a fair and transparent hearing in front of an impartial tribunal. To be told that you're already 2 points down, it would be disappointing.
No, I think that flows from a case of Lucas, where the judge has to...
No, Lucas is completely different.
Right.
Lucas is a lies direction given in the criminal courts, where a judge, where the jury are told, because the judge doesn't know that whether they're going to find lies, if you find that they have lied, and the prosecution say he lied in this way and that way, and he says he didn't in A and B, then don't convict him because of it. But it is completely different from starting off on the basis that the witness is likely to be lying.
Lord, I understand that. The reason why I say it is that the next two sentences, or 3 lines...
That's why I didn't complain about the next sentences. All I am concerned about is that if this has crept into family jurisprudence, I can't see it as fair in any sense or form.
Now, I'm probably explaining badly that Lucas has been imported in a number of family cases.
Same as character and all the rest of it. Yeah.
And those lines I read pretty clearly as flowing from the family decisions in relation to the Lucas direction. The first sentence, well, I'm not sure what I can say.
No, you didn't draft it, and it's not the basis on which the appeal is being...
I think it's an unusual start. Am I allowed to say that?
Well, I think what we can do, and we will do, is just quietly investigate where this might have come from. That the trial judges have of lots of guidance, query helpful or not, in relation to some fairly basic tasks in this area. And one of these areas is to do with lies. And it's been expressed in a number of cases in this court and in the High Court in different ways. I somewhat doubt that, that this judge is the first judge to express it in this way, but we do encourage judges, rather than to cite pages and pages of authority, to put in their own words what they think they're doing, and whether this is a paraphrase, correct or incorrect, or a quote, I think we can pin down.
No, I think all I can say is that, I mean, just practicing, I know it is obviously a frequent occurrence that the court is not given an explanation for injuries. I know that's trite, but that is it, the truth. So whether the judge was trying to say that,
yes.
I don't think I can say any more.
Thank you.
Anything else? No. Thank you very much, Mr. Bennett. Is there any reply on, firstly, the
just in
appeal?
respect of the last comment that my Lord Dingemans made, the judge did give himself a Lucas direction as well, of course, in this case, in paragraph 200. Just as a matter of interest, and why he did that is not quite clear. I think the main theme of my learned friend's submissions related to the impact of the medical evidence, and I think I've made my position in respect to that already clear, and I have nothing further to add.
Right, well, what I would like to trouble you with is, just for a moment, is the discussion that we had about if you were successful to the extent of having your findings set aside.
Yes.
The current position of the local authority, but subject to the input of the Guardian, and subject to your client having an opportunity to comment, and subject obviously to the interveners being involved in discussion, is that the local authority would not seek a further trial.
Yes.
But that would leave the situation whereby the injuries to the child were unexplained.
Yes.
And that's what would be recorded, alongside the fact that the medical evidence had suggested a non-accidental cause, but in the end the injuries were unexplained.
Yes.
So the opportunity for there to be a finding that there had been a fall and that this fall had caused the injuries would be gone.
Yes.
Right. So there is a decision to be taken by your client and indeed by the interveners, but I think essentially by your client
Yes.
and by the father in this regard. Now, for that purpose, some time would be needed for instruction to be taken.
Yes.
For each party to understand each other as to what this meant and what could and could not be done. So to take, for example, the suggestion that there'd be a child in need plan, that there would be ongoing support, and that there would be a discussion as to when the oldest child might return to the family home. It is extremely important, if this road was travelled, that there would be no misunderstandings about those matters.
Yes.
So I mean, I'm not asking you for a response to any of that unless you choose to offer one, but is there anything about that process?
No, there's nothing about that process that we would comment on or object to. We have started taking instructions on these points over the short adjournment with the mother, but one of her main considerations is that she would like to discuss what you've just really outlined with her husband.
Yes.
Before.
Yes, I mean, what it would mean in practice is that the supervision requirements would, at the point of agreement, unless there was some agreement otherwise, would fall away.
Yes.
Because at the moment, I take it, when we look into this in more detail,
We
there
look
are
into
supervision
it, and
requirements.
yes, as I say, I mean, I've taken instructions from her about this. I have an impression of what she's thinking, but the priority for her is to talk about it with her husband.
Right. Any further questions? Yeah. Right. Well, thank you both very much. We'll rise now and come back as soon as we can.
My Lord, just before you do, can
Yes.
I just mention something to Mr. Newton?
By all means.
Please.
beyond his competence, I think. I heard from someone, a solicitor in Peterborough, who is a friend of the clerk, Judge's clerk, who said that he really worried about this case. It's been more, he really worried about it. I found it very, very difficult. But I just think that it was a... But he could have wrapped it up so easily. He could have... The demeanour, I didn't like it. I didn't believe it. I was hoping he would, one way or the other. I didn't want to be
Are they coming back?
Yes.
I can't get you a clue because you're coming
JS signal.
Yes, exactly. Did you report?
Bow at you. Sit onto my advice.
Court rise at table.
Thank you. We've considered the position that's been reached, and we'll proceed in the following way. We will let you have our decision and the reasons for it as soon as we possibly can, in the form of a draft judgment from each of us, and at that point, rather than simply moving to corrections and hand down, if the judgment should be in favour of the appellant in relation to the setting aside of the findings, we will want to hear submissions from the parties as to what should happen next. There has been a useful exchange of views on that question in the course of the hearing, but I hope that those who are present today will now widen that discussion in case it should become relevant to all the other parties, the children's father, the children's guardian and the other interveners, so that following the hand down of a judgment, if it is in favour of the appellant, then there is a discussion to form a draft order as to what the next steps should be. But I will neither preempt our decision nor any discussion of what next steps might follow a successful appeal until other parties have had the opportunity to be involved in that discussion. Apart from that, it remains to us to thank the parties and to encourage them, indeed to require them, please, to look carefully at the conditions upon which the draft judgments will be circulated, which are going to be in the standard form applicable in this court. Before we rise, do either you, Mr. Newton, Ms. Hunt, or you, Mr. Bennett, want to make any further contribution?
No, thank you, Lord.
Right.
Thank you all very much.
Court rise at table.